So what we'll cover in this session are scenarios where a claim might be brought and who by, when the time limits for claims arise, time limits for those claims, and also how they interact with standstill periods, the automatic suspension, and then the other remedies themselves. Generally, that's 30 days from the date of knowledge or ought to know, or for declaration of ineffectiveness, 6 months unless it's been brought down to 30 days. The standstill period is something else. This is the period during which a contract cannot be entered post-award. This is mandated by Regulation 87 of the regulations. This period is triggered only on a valid contract award notice issued under Regulation 86. The amount of times I've seen an invalid notice and then the contracting authority has had to reissue and restart the standstill period. A standstill period must be observed, a valid standstill period, in order to then enter the contract. Because it's costly, because it's quite draconian, there's naturally limited case law. The first English declaration of ineffectiveness came in the case of Faraday and West Berkshire Council. Funny enough, this was actually through a genuine error. The parties had entered into a development agreement that they thought was compliant with the law. They considered it to be a land deal following earlier decisions of the court, a misunderstanding of those earlier decisions, I hasten to add. Interestingly, though, the court actually said, no, this is not a public contract, public works contract at the outset, but through the operation of the development agreement, at a certain point, the council commits itself to a public works contract. At that point, it cannot, through the contract, go out to advertise it. It is therefore a direct award without advertising, and it's grounds for a declaration of ineffectiveness.